self-discriminatory double jeopardy. What is this double jeopardy? Have you heard about it? Even protection against the ex facto law, and also, yeah. Okay. So here, protection against ex post facto laws. This is nothing but which is illegal. If a person is arrested against illegal activity, then Section 20 of Indian Constitution speaks. So, as ex facto law is one that retrospectively makes an act illegally and increases the penalties for crime after it was committed, okay, or changes, and the legal consequences of any actions that were lawfully when done. Such law will be prohibited, and which can be treated as violate principles of fairness or justice. So many legal systems, including United States of India or in United States or India, Article 1, Section 9 and 10 of the Constitution, which clearly speaks about the ex facto law, not only for India but even other countries also. But with regard to India, Article 20, subclass 1 of the Constitution, which clearly speaks about ex post facto criminal laws which are expressly prohibited. Example, if a law is passed today increasing the punishment for a theft, it cannot be applied to someone who committed theft in the last month. Okay, are you following me? Very good. So here it is guaranteeing prohibition against double jeopardy. Correct. Double jeopardy is the protection against being tried for punished more than once for the same offense. So this um, is nothing but it is a fundamental rights of safeguard, or which is clearly ensures fairness and preventing harassment by a repeated prosecution for the same crime. So, in the United States of America, in the Fifth Amendment, which clearly provided the protection against double jeopardy. So, Article 20, subclass 1, Article 20, subclass 2 of the Indian Constitution clearly states that no person shall be prosecuted and punished for the some offences more than once. Okay, so here the more important key points of this is it applies only for criminal laws, not for civil. This particular double jeopardy will apply only in criminal, not for civil laws. Example, if a person is acquitted of theft and they cannot be prosecuted again for the same theft based on the same evidences. Okay, so there are many case laws with regard to the same leading case laws about the same under the Indian Constitution. Those are the main protection against ex post facto laws. The United States case laws has been taken. Even in India, Kedarnath versus State of West Bengal, and Maqbool Hussain versus State of Bombay. Maqbool versus. Please, when I am discussing about some case laws, you need to write a make a note of the points. Okay. First of all, I said that it is a case law of Kedarnath versus State of West Bengal. In this case, a person was charged under the criminal provisions that imposed harsher penalties retrospectively. And then the other case, even in this particular case, the judgment of the Supreme Court, the judgment of the Supreme Court of India, Article 20, Subclause 1, Constitution clearly protects against the retrospective application of the penal laws. And then this reinforced the principle no person can be subjected to the criminal penalty greater than what was prescribed when the offense was committed. That is what the person or law is speaking. And the another case, Shivdatt Rai. Did I told the? Please make a note of this citation of Kedarnath versus State of West Bengal. The citation is AIR 1953. AIR 1953. One second. AIR 1953. Supreme Court 660. 1 second and please be online. Kedarnath versus State of Bengal, AIR 1953, Supreme Court 660. Okay. In this case, as already explained, one person cannot be punished for twice. Okay. The another one is Shivdatt Rai versus Union of India. Shivdatt Rai versus Union of India. This is also speaks about the Supreme Court clearly held that Article 20 does not apply the proceedings unless it is sales tagged. So actually this is a civil sanction. So where they clearly mentioned that it is nature of revenue case. So the court held that penalty imposed by the Department of Income Tax authorities for violation of the statutory provisions are civilian liability. Henceforth, the law will be not applicable to civil cases. It is applicable to criminal cases only. So as already told you that a new tax law imposed retrospectively liability for the tax evasion, and the petitioner challenged the validity of the Article 20 subclause 1. But the court clearly clarified that Article 20 subclause 1 applies only to criminal laws but not in civil or taxation law. So here you have to understand that the difference between civil and criminal liabilities in applying the prohibition on ex post facto laws. Okay? Are you clear? The another case, there are many case laws. Then Venkataramana versus Union of India. Venkataramana versus Union of India. This is AIR 19 54, 375 is the page number. Okay. So finally, what I would like to suggest is that protection against exposed facto loss, Article 20, subclause 1, prohibits the retrospective application of a criminal laws that criminalize the actions retrospectively, increasing punishment for a past offense, and guarantees against double jeopardy. Article 20, subclause 2 clearly applies only when a person is prosecuted and punished for the same offences, and does not apply to civil or administrative action. It will be applicable to only criminal cases. Is it clear? Is it clear? Yes, no? If you have any doubts, please you can make a note. Yeah, Venkataramana versus, what do you want to, sir? You want a citation? Venkataramana versus Union of India, yeah, IR 1954, 375 is the page number. Okay. And next is privilege against self-discrimination. Privilege against self-discrimination. And right to life, right to equality, you know very well. That is Article 20, subclause 3, is clearly speaks about the privilege against self-discrimination or self-incrimination. Self-discrimination is different and self-incrimination is different. Article 20, subclause 3 of the Indian Constitution clearly says that no person accused of any offences shall be compelled to be witness against himself. So this is the nothing but self-incrimination. So that is a privilege is given to one individual. So this provision protects the individuals from being forced to provide evidence that may incriminate themselves during the criminal offences. Okay. The another privileges or key points of the privilege against the self incrimination are, it applies only criminal cases. It won't apply for civil cases. Protection against compulsion. Voluntarily admissions are not covered. And this self-incrimination is only for protection is available to the accused but not the witnesses. And compulsion includes both physical or psychological coercion. So this protection against self-incrimination is applicable to only criminal cases. So we have a very leading case laws with regard to the same. How many of you heard about it? Which article? Article 20, subclause 3. Self-incrimination. In simple words, we can say that it applies only implicating the exposing one's own self-prosecution. So we know very well one legal maxim is a nemo tenture prodere accurare sepisum. NEMO TENETEUR nemo tenture prodere PRODRE accusare ACCUSSARI episums SEIPSUM, which means no man is obliged to be a witness against himself. Okay, are you following me? full for USA, UK, also. The main ingredients of, as already told you, it will be applicable to Canada. It takes against the compulsion, voluntary admission are not covered, and execution will be available only accused but not the witness. Compulsion includes both physical and psychological coercion. Okay, and in this particular point, there are many case laws are available. We'll see what are those case laws. The case Satpathy Nandini Satpathe versus PL Dhani. PL Dhani. Yeah, correct. 1 second. Accurate Sepisam ACCUSSARE Sepisam, correct. RE Raman ACCUSSERE. There should SSRE, double SERE, it should be. Just a minute. SSRE. SSERE. Okay, this is correct. Okay. This case, that is Nandini Satpathy versus PL Dhyani 1978. This is very important case law, which you can find it in everywhere. I mean to say, in indiacom.com. This citation is 1978 LR 107. So this is what it exactly this case is all about. The petitioner was a former chief minister who refused to answer the certain questions during the police interrogation, invoking Article 20 subclause 3. So in this case, the broader scope of this article 20 subclause 3 is been subjected to what exactly the including pre-trial stage or like police questioning and etc. So the Supreme Court thoroughly understood about the right against self-incrimination includes protection during the police interrogation. Even the accused has the right to remain silent and cannot be compelled to answer questions that may be incriminate them. This is what the particular act clearly speaks about the Nandini Saptpadi versus Jani PL and others case. Okay, and this case basically having the multiple facts in this issue. Even you can take the Menaka Gandhi passport case also. That is also section 10 subclause C of the Passport Act. Even Article 19, Article 21, even Article 20 subclause 3 also will be comes into the picture. Okay, and the other case leading case law relating to the um, this self-incrimination is Selvi versus State of Karnataka. AIR 2010, Selvi, Selvi, Selvi versus State of Karnataka. You can make a note of this. This is AIR 2010 Supreme Court 1974 is the page number. Okay. In this case, what happened is the use of necroanalysis, polygraphy tests, the brain mapping techniques, based on the accused person, was challenged that are violating the Article 20 subclause 3, saying that his rights has been violated. And this case significance is that it is strengthened the protection against the self incrimination by rejecting the involuntarily scientific test. So the Supreme Court clearly said that the polygraph, polygraph test or necroanalysis, brain mapping techniques violates the rights against the self-incrimination because they involve compulsion and invade mental privacy. Okay, are you following me? Yeah, following me? Yes or no? Yes or no? Please. Very good, very good, very good, very good, very good. There are many case laws, but these case laws are very, very important. Next point is the right to life and personal liberty. How many of you know about what is right to life and personal liberty? Which article is speaks about? Yes, somebody was asking something. Tell me, Mr. Vishwas, if a person expert is telling lies, remain silent. See, police people can easily identify that who is the truth, who is not truth. So accused person always tells lies. Yeah, of course. But the thing is that not all. But criminal law, what it is says that you can punish 100 accused, but you can't punish one innocent person as a accused. Okay, this is what it says. So that's the reason in Telugu also we will say that 100 అపరాధులను శిక్షించవచ్చు కానీ ఒక్క నిరపరాధిని శిక్షించకూడదు అని. Police is not the people who can punish the accused and also him guilty. Yeah, of course, based upon the facts and circumstances, if it tells lies, police people or will be taken. The facts and here you have to understand the principle and to bring the criminal law into the constitution. You study the constitution as these are principles as a foundation. Okay. But you can't bring criminal law into constitution. Next point is that right to life and personality. Article 21 of the Constitution clearly says that no person shall be deprived personal, personal liberty except according to the personal procedure establishing by the law. So that every individual has the right to life, has the right to life, and with dignity, and also safeguards personal freedom. Now, in this particular Article 21, includes not just physical existence but also defined life. So it is covers broad range of the rights such as right to privacy, health, education, livelihood, so on and so forth. Okay, and in this particular case, in this particular Article 21, protection fairness is very essential for deprivation of the life and liberty. So you can take many case laws, Menaka Gandhi versus Union of India, 1978 case. In this case, the petitioner passport was impounded by the government without providing her an opportunity to be here. That is principle of natural justice. So here the scope of the 21 include fairness and due process, making it very cornerstone of the Indian constitution. So in Menaka Gandhi case, the Supreme Court has held that procedure established by law must be fair, just and reasonable, not more than that. Even you take K.S. Puttuswamy versus Union of India 2017. In this case also was challenged the constitutionality of Aadhaar, that is a biometric identification system, on the grounds of privacy infringement. So in this case also elevated the privacy to the state of fundamental right under the constitution. So the government, the Supreme Court clearly declared that the right to privacy as an intrinsic part of the right to life and also personal liberty under the Article 21. Even you can take Vishaka versus state of Rajasthan, Olga Telsis versus Bombay of Municipal Corporation 1985. All these places also very good example for the right to privilege, right to privacy and um, right to liberty and privacy under Article 21 of the Indian Constitution, right to life and personal liberty. Article 21. So there are many case laws with regard to right to life. Am I correct or not? Do you know how many case laws are there? Yeah? Yes or no? Can you hear me or not? Am I audible? Okay, voice is breaking. Okay then, because I am not using Wi-Fi here, because I am in out of station. That's the reason. Then I'll do one thing. Tomorrow morning I will try to take the class. Okay, morning hours, morning 9 to 10, something like that. Is it okay? Because I'm not using. Yeah, I will share it. Thank you so much.